Let me restate that. It was for today and future court, any future court hearings. That's what the limited appearance says.
Okay, so Mr. Cardello-Smith, so you no longer want his services?
Yes, ma'am.
Okay, so he's free to go and he doesn't need to appear anymore at any other hearings?
For this hearing is what it is. I'll talk to him.
Well, okay, so Mr. Cardello-Smith.
If that's what has to be done, then we'll go with that today. Yes, ma'am.
When you retain counsel, they represent you going forward. If if you were to represent yourself today and not allow him, then effectively that's not appropriate. So are you releasing him from all further hearings?
I'm releasing him. Yes, I'm releasing him. Yes.
Okay, so you understand he won't appear for you anymore?
Yes.
Okay. Mr. Hughes, are you satisfied?
I am. I would be, I'd like to sit in on the hearing though, so I just get a further understanding with the court's consent, opposing counsel's consent, and Mr. Smith consent.
Any objection to him remaining? He'll mute his device and turn off his video.
No set up a call with me. I'll tell you why, Mr. Hughes.
Well, it's a public hearing, so.
Well, Your Honor, the only reason is because these people have filed a motion to set it aside, and I have not had any time to view the motion. They want to get right into this and just start banging me out when I've had no opportunity to view anything. And if he's speaking for me, I can't say the information that became available. Mr. Hughes has done.
That was my question. Mr. Cardello-Smith, we've released Mr. Hughes. He is no longer your attorney. Do you object to him observing the proceedings today?
No, I have no objection whatsoever.
Okay,
none.
So Mr. Hughes,
hear that. I apologize.
It's okay. Mr. Hughes, can you mute your device and stop and your audio and turn off your video?
Turn off the video. I will. Thank you.
Okay, so he is muted. His device video is off. So, all right. So I have David H. Fink, P28235, appearing on behalf of the defendant, and that is Ms. Spade, F-I-N-K. And then I have Nathan Fink appearing as well, P75185. I have David Berg, and that is B-E-R-G-H, P83696, appearing on behalf of the defendant. And let me double check. I don't, okay. And then I don't have anybody else. So I don't see anybody else. I don't see Calder Burgum. I don't see him logged.
Calder Burgum is assisting us, but he is not going to be on the record today. And Your Honor, I would also note that Erica Wolf is.
I haven't called her yet. Yep, I got her.
Sorry, I apologize.
Thank you. So then I have Erica A. Wolf, that is with 2 Fs. There is a Pro Hoc Vici motion pending. And she is not participating today, but she is observing because that Pro Hoc Vici motion is still pending. So it is 11:06. This was scheduled for 1 hour today. The last time we were here, there was an emergency motion. The attorneys were advised we had 30 minutes only because it was an emergency motion on my Monday morning motion docket. Today, I have just been on the bench since 8 o'clock. So we have until 12. So I'm assuming, Mr. Fink, you are going to argue. Is Mr. Nathan Fink or Mr. Berg going to be placing any argument on the record today?
We don't anticipate that, Your Honor.
Okay. And then, so what I would say is Mr. Cardello-Smith is appearing in pro per today. So I have read everything. As I said, we don't need to reiterate everything. Mr. Fink, you've already had an opportunity to sum up part of your motion. You had 20 minutes the other day. So Mr. Fink, I'll give you 20 minutes. I'll give Mr. Cardello-Smith 20 minutes. And then of course, because it's your motion, I'll let you follow up. All right.
Your Honor, I have to object to
Your Honor, could you please ask Mr. Cardello?
Okay, hold on a second, everybody. We're talking over each other. Mr. Cardello-Smith, what is your objection?
This is my reason. On all I received so far were the notices of the motions for summary or motion to set aside your default. Everything I've been given were just notices. And then after I made my argument on Monday about these people presenting forged documents from these people who are feeding them, They did exactly as I said they would do. They filed all these supplemental exhibits, all these motions, the emergency motion, a supplemental emergency motion. I have not had literally no time to argue any of this or research, to research any of this, prepare a defense to this. It was all given to me on Friday.
Your Honor,
At
I
least
would.
60 pages of stuff.
Mr.
Your Honor,
Fink,
Your Honor.
Mr. Fink, everybody listen, this is my courtroom, okay?
And I
I'm
respect
allowing
that,
Mr.
Your Honor.
Don't talk over me. I'm allowing Mr. Cardello-Smith, who is an inmate, to make a statement, and then I'm going to discuss that with them. I will afford you an opportunity to respond. Mr. Cardello-Smith, this is an emergency motion. Motion practice allows for those things. Mr. Fink, I'm presuming that the motions were expedited to Mr. Cardello-Smith with the Michigan Department of Corrections.
They were, Your Honor.
Okay, and when were they sent to Mr. Cardello-Smith?
As soon as they were filed, and Nathan Fink can provide more detail in terms of the procedure that we followed. We delivered them to Mr. Fager at the prison, and in each instance, we got confirmation from Mr. Fager that they were hand delivered to Mr. Smith. I do want to ask one thing, Your Honor. Here and previously, Mr. Cardello-Smith has spoken to the court many times. I have not seen him being sworn. We've seen the transcripts and he hasn't been sworn. We'd ask that he be sworn before he continues to make representations to the court.
Nathan Fink, perhaps you can give me the date and time that they were provided to Mr. Fager and served upon Mr. Cardello-Smith.
Yes, Your Honor.
Yeah, Your Honor, can you hear me? Because I'm
I can hear you.
the other. Okay, so this is Nathan Fink, Your Honor. And I'm
Judge, we're not getting a good,
Okay,
Fine.
Nathan Fink, go stand behind David.
Well,
Fink,
okay, I can
please.
mute, if the court would prefer, I will mute while Nathan Fink speaks.
Okay.
That works.
All right. Unmute your device, Nathan Fink.
Okay, can you hear me, Your Honor?
Yes.
Try again.
Okay, can you hear me, Your Honor?
Yes.
Thank you. Okay, I'm just pulling up the various service documents. Which, and Your Honor, we did also provide copies of proofs of service to the court, and Mr. Fager, who is the litigation coordinator at the prison, has advised us that he has been sending original copies of those to the court for filing. I'm pulling up the documents right now. Okay. On Friday, September 13th, 2024, Mr. Fager provided a personal service on prisoner and affidavit document to us confirming that he had served the following documents on the plaintiff, Mr. Cardello-Smith: the limited appearances of myself, David Fink, David Calder-Burgum, notice of hearing of the emergency motion to set aside the default and default judgment, notice of hearing of defendant's emergency motion to dissolve temporary restraining order and or preliminary injunction, and defendant's emergency motion to set aside default and default judgment and brief in support, and defendant's emergency motion to dissolve temporary restraining order and or preliminary injunction with the brief in support. Those were served on Friday, September 13th. Mr. Fager also served prisoner Smith with the notice of hearing after we received the confirmed date and time from the court. We filed the re-notice of hearing. He also served a copy of that on the plaintiff on Friday, September 13th. Mr. Fager on Tuesday served the notice of hearing of the emergency motion. We filed another re-notice of hearing, and that specifically related to our motion for leave to file a supplemental brief, which was filed with the court yesterday. And then this morning, Mr. Fager provided us with a proof of service or an affidavit of service confirming that he provided the document that we filed this morning, which was the notice of additional exhibits in support of the defendant's emergency motion to set aside default and default judgment, and the motion to dissolve TRO and or preliminary injunction. Mr. Fager confirmed that he provided a copy of that to the plaintiff this morning after we filed it.
Mr. Cardello-Smith, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, as always.
All right, so Mr. Cardello-Smith, we do have a notice of hearing showing that those documents were served to you by Mr. Fager at Michigan Department of Corrections.
The notice of hearings were served. The briefs in support were not served until well after the notices. The video footage will show Mr. Fager and the size of the amounts of paper. Excuse me, I'm sorry. The documents that they're speaking about will show Mr. Fager making at least four or five trips down to segregation where I'm housed, delivering different papers, different sizes over a different period of time since Tuesday. Excuse me, since the day of our last hearing and before that.
Okay.
And I didn't get everything officially until yesterday when he made several trips down to my cell. I literally have not had time to view any of the main arguments, any of the grounds, any of the case law, because I can't access any law library. So this emergency hearing could very well violate my opportunity to do the right thing and know exactly what they're bringing at me, know exactly what they're trying to give me under the conditions I'm under. I can't work under their conditions or the conditions that I had because of my current situation in my housing. So I need an adjournment on this at a minimum, or because I know they're looking to get the TRO done so Mr. Holmes can sell his mansion. That's what they're doing. But I got rights here, and I don't want my rights violated any further than this guy already has. So I'd have to ask for an adjournment, or at a minimum, Your Honor, have reserved on the record my claim that I have not viewed everything, any of the cases to make sure they're in there. Also, the person who's giving them all this paperwork, Mr. J. Fager, before any of these cases got started and looking at one of their own documents, I've filed many documents challenging forged documents by this man.
All right, so Mr. Cardello-Smith, I'm going to cut you off here, all right?
I'm sorry.
This is an emergency motion.
Okay.
It's a fairly typical part of motion practice.
Okay.
Whether or not we have documentation that you were served with these, we will proceed today. If you have a problem with that, you can later file a motion for reconsideration. But at this point, I'm going to stop you, and we're going to move to Mr. Fink and Mr. Okay, and Mr. Fink, you have 20 minutes, and then I'll go to Mr. Cardello-Smith for 20 minutes.
Yes.
What I would say is that we have a lot of people, and Mr. Cardello-Smith, we get echoes from where you are. Not as bad, because thank you for opening the door, but I'm going to need everybody who's in here to remain quiet while Mr. Fink is speaking. And Mr. Fink, your 20 minutes can start now. I understand you've already argued for 20 minutes, so you're getting that extra time. So you may proceed.
Your Honor, very briefly, I would ask first that Mr. Smith mute his.
I can't mute him because he's with
Okay,
MDOC,
okay,
and
no
then it
problem.
gets stuck.
Give me my word, I'll be quiet.
No problem, Your Honor. I'll go
Okay,
forward.
thank you.
Your Honor, one quick thing I want to note on the record, and that is that this objection that we're now hearing from Mr. Cardello-Smith was not made on Monday when we were in court, was not made previously before we came here. I heard nothing from Mr. Hughes when we spoke about this issue privately and separately, and this is a complete surprise to us. And of course, it makes no sense because he's been served with everything over and over, and we filed our proofs. Now, Your Honor, thank you for providing us with this time. I want to be clear about something. We have filed a lot of pleadings here, a lot of documents here. And the reason we've done that is this is an extraordinary circumstance. The relief that the court has awarded to Mr. Smith is not a small thing. The relief awarded to Mr. Smith of $100 million, and most importantly right now, a temporary restraining order, is so extraordinary that it requires, and we appreciate the court providing us this immediate hearing. Your Honor, previously, we explained to the court, and I'm going to be very brief on what we've talked about before. We've provided an affidavit for Mr. Combs establishing that he was never served, that he wasn't at the location. And of course, the court saw the card, and there's no question that that card, if it has a signature, that's not a signature that says Sean Combs, nor is the handwritten print saying Sean Combs. And most importantly, we showed the court, we won't show the court again now, the two cards, which are both in the court file and which show that the card was clearly doctored to suggest or to convey to the court, to frankly, to lie to the court as part of all of this fraud that he's been trying to perpetrate on this court. He doctored the card to make it appear that in fact it had been sent addressee only, but it was not. That was not the form, because the court has available to it the clear evidence that the initial card, which is also in the court file, the initial card shows that addressee only is not checked, that restricted service is not checked. Now, we also, I'm trying to skip through some things here, but we've also learned, and now we have the transcript of this, that at the temporary restraining order hearing on August 7th, as part of this broad fraud that he's perpetrating on the court, Mr. Combs lied extensively and very significantly. What he said on the record was that he said that 2 weeks before that hearing, the hearing was August 7th. I'm sorry, Your Honor.
Hold on, I don't know what's going on here, so hold on one second. I think that we are getting feedback from, okay, go ahead. I'm sorry, Mr. Fink, go ahead.
No, I appreciate you interrupting me for that. We want you to hear what we're talking about. Okay. At the August 7th TRO hearing, Mr. Smith, told the court that Sean Combs had visited him in prison within the past 2 weeks. Now, as we've already proved to the court, that absolutely didn't happen. We subpoenaed the visitor records. We showed the court the visitor records, and the visitor records show that the only visits he's had since January 1st were one visit from his attorney. Well, he's not his attorney now, but from Paul Hughes, and 2 visits from William Proctor, who has provided some media assistance to him. In the August 7th hearing, Mr. Combs, in making his misrepresentations to this, Mr. Smith, in making his misrepresentation to the court, I apologize for this, said that Mr. Combs, when he visited, and this is what these are his words, also said he won't be filing an answer to the complaint. He said, you can find me in default or whatever. Blatant lie. Nobody would have said that. And of course, there was no such meeting. And this was all part of his process of trying to persuade this court that a default was appropriate, that a default judgment was appropriate, that a temporary restraining order was appropriate. It's undisputed on this record that Mr. Combs was not served, and that should be the end of the inquiry by this court. But it doesn't have to be, because as we look at the 2 types of orders that were entered, the temporary restraining order and the default judgment, none of the necessary prerequisites occurred regarding the temporary restraining order. Of course, this court had to first find that there was a likelihood of prevailing on the merits. I won't bore the court with going through this much more. We already showed statute of limitations ran on every claim. And if the statute of limitations is run, there is no likelihood of prevailing on the merits. Also, Mr. Combs has denied every single fact alleged in the complaint. And now we have, and we provided to the court, another affidavit, the affidavit of Wayne County Prosecutor Kim Worthy. We had that delivered to the court this morning and delivered to the prison so that Mr. Smith could see it. And Ms. Worthy has indicated that, as the court knows, in the court file, Mr. Smith argues that he had an agreement with Kim Worthy to commit a bunch of felonies, and that he was being put in prison for no good reason. Well, She has indicated she never saw, and she's sworn under oath, she never saw the documents. She didn't sign the documents. The signature is not her signature. She never met Mr. Smith. She never met Mr. Combs. She never entered into an agreement with either one of them. She's a third party who's come and off and provided that. And obviously that's significant both for success, for prevailing on the merits, but also obviously for the meritorious defense. Now, Your Honor, this witness has no credibility. Aside from all the inconsistencies we've heard already, the court can be and can consider the fact that currently he's serving time for 4 counts of first-degree criminal sexual conduct, 6 counts of first-degree criminal sexual conduct during commission of a felony, 2 counts of kidnapping, 2 counts of third-degree criminal sexual conduct. That's rape. He is serving, his earliest release date would be July 8th, 2038. This is all based on evidence this is all in the record of the Michigan Department of Corrections, very easily found online. Now, let's look at his record as a litigator. This man's been in court more times than I have, Your Honor. If you look at his record, you'll see that, and we're going to talk about that in another way. He has filed so many frivolous lawsuits that not 1, but 2 federal courts, and we just found the second one. We provided that in our supplemental brief to the court. Judge Lawson in the Eastern District, Judge Maloney in the Western District, both found that because he's a serial litigator who's filed so many frivolous lawsuits, he's not entitled to the special provisions provided to prisoners under 28 U.S.C. 1915. Now, Your Honor, even if he were credible, and he's not, even if you didn't know from this evidence all the ways he's already lied to this court, you could just look at the allegations that he's made and see that on their face, they are inconsistent and absurd. As far as inconsistencies, of course, we showed the court previously the Monroe case. We showed you that he filed the exact same case in Monroe that he filed here. And in order to advance his fraud on this court, he whited out the words Monroe and 2 places in the new complaint that he filed in this case, but 2 identical complaints, both filed on June 10th, 2024.
Mr. Fink, we did cover all this the last
And
time. I just don't want you to waste some of your 20 minutes on stuff you've already gone over.
I appreciate that. And so what I'm going to do right now, Your Honor, is I want to show you the new exhibits that we have. And I don't have to put them up on the screen. I'll just tell you, I believe the court has them. There are 3 new complaints that we found that were filed in Macomb County. And what I'd like to do is, well, I'm just going to jump to the punchline here, Your Honor. He filed these 3 complaints, and in each of these 3 complaints, he appended he included what he calls a mandatory disclosure statement. Now, in this case, he filed a mandatory disclosure statement, and we're going to share the screen now and show you. These are 4 different mandatory disclosure statements that this plaintiff has provided. On the bottom, you see the one in this court. The plaintiff, he writes, has filed 3 state lawsuits, 2 federal lawsuits, I assume that's 3 civil appeals and 3 criminal appeals. That's what he wrote here. But if you look up on May 2nd, 2023, in the Macomb County case of Cardello-Smith versus DePiola Carpenter, he wrote, this plaintiff has filed 124 state and federal civil cases and appeals and over 40 federal appeals. In the case against Preston, he filed on July 3rd, 2023. He wrote then, well, the plaintiff has filed 4 state and federal civil cases and appeals under civil jurisdiction. And then on September 6th, he filed a case against, among other people, Mr. Fager, who's been serving the pleadings. That was on September 6th. And in that one on the mandatory disclosure, again, this is right after he filed the case here. He filed the case here in June, saying 3 state lawsuits, 2 federal, 3 criminal appeals, 3 civil appeals. In this case, again, in Macomb County, he said 131 civil lawsuits at the state level, 141 criminal appeals at the federal level, 64 civil appeals at the federal level, 63 appeals and criminal cases at the federal level. This man will say and do anything to advance his case. It does not matter if it's true. Now, we can take that screen down. He also has made absolutely ridiculous allegations. What I'd like to see now is
Mr. Fink, I just want you to know, I'd rather stick to the merits of the case. I understand that he may be litigious, but can we just focus on the merits of why you're requesting what you're requesting in the relief?
Yes, Your Honor.
Thank
Very
you.
quickly, I will point out that, and I won't, we don't have to show it to the court. I'll point out that he makes a claim of in this agreement that there was a deal 2 days after the alleged incident, that there was a deal in a meeting with Kim Worthy, and he provides the handwritten agreement. If this was supposed to be, you can see on this screen, supposedly her signature, but you can see her real signature. But more to the point, Your Honor, he makes the absurd allegation, the completely indefensible allegation as part of this case, that a conspiracy involving then Sheriff Robert Ficano, then Circuit Recorder's Court Judge Worthy, then Director of Wayne County Department of Community Justice Warren Evans, a couple of police officers, Sean Combs, that he made a deal with all of these people that they were going to lie about what happened. They were going to put him in jail. They were not going to prosecute related to his allegations. The absurdity of these things is only matched by how ridiculous they look when you observe them. Now, putting that aside, we also have evidence that he's been suborning perjury from prison, or we believe he has, and we showed these documents to the court. I'm sorry. In our supplemental brief, we provided the evidence of how it is that he has been, along with the exhibit we filed today, we've shown the court how he suborned perjury in trying to have a motion for reconsideration filed related to the allegations of rape filed by Carly Carpenter, the woman who he was convicted of raping her, but she filed a habeas petition and a motion for reconsideration, which we've provided to the court. You can see that motion for reconsideration was virtually dictated from prison by Mr. Smith. I won't waste the court's time on all the details of that because it's available to the court. The court can review it. And instead, I want to get down to the basic rules, the standards for the temporary restraining order and why they weren't met here. Your Honor, there must be a showing of irreparable harm, but the rule is very specific. There must be specific facts shown by affidavit or by a verified complaint. There was no affidavit here. There was no verified complaint. There was no sworn testimony before the temporary restraining order was entered. Second, there had to be, but I'll just quickly say that there was no analysis of the balance of the harms. And in this case, certainly the harm to the plaintiff is nothing like the harm from not issuing an injunction, is nothing like the harm to the defendant who is being restrained in the use of his own property without any due process, without any analysis of the facts or the law, and without any evidence supporting the injunction. Now, regarding the public interest, it can't possibly be, these are the four factors. It can't possibly be in the public interest. It can't possibly be in the public interest. I skipped something and I shouldn't have. When I talked about irreparable harm, I was in such a hurry here. I told you that there were no proofs. But more importantly, the only harm alleged here is economic damages. And the law could not be more clear that irreparable harm does not include economic damages. There has to be proof of irreparability. If that were not the case, then every single personal injury case would justify entry of a temporary restraining order against the defendant if the court believes that there's any credibility in that case. That's not the law. There has to be a judgment first. There has to be some attempt to satisfy the judgment. There has to be evidence or a reason that the judgment can't be satisfied. There has to be irreparable harm, and there was none here. And I apologize for not mentioning that when we talked about the irreparable harm. Regarding the balance of the harms, obviously tremendous harm to Mr. Combs, no harm at all to Mr. Smith. in the absence of the injunction. Regarding the public interest, it is simply not in the public interest to pursue or to enforce an ex parte prejudgment attachment. The constitutional law is very clear. Until there has been a judgment with notice and opportunity to be heard, until that has occurred, there cannot be this type of remedy. And if this court enters this order, it sets a precedent that's a very, very dangerous precedent. It would, and furthermore, what we have here is with no proofs, all kinds of inconsistent claims, you have a prisoner who simply finds a very famous person and makes some atrocious, extraordinary allegations against that famous person. Well, this would create a circumstance where prisoners all over the country will be filing these phony claims against anybody they can hear of and learn about online. Finding somebody's address is easy enough. In this case, he got the wrong address, but at least he got a location that was owned by the defendant. But it's simple to do this from prison. And there's a reason that we have the rules that we do. A temporary restraining order is an awesome order with awesome power of the court being imposed. And that's why there's so many rules about it. And I want to talk about those rules. One, under 3.310B3, the injunction on a temporary restraining order can't extend more than 14 days. This order was written as 90 days. And we don't blame the court. The court didn't write the order. The court entered the order that was prepared by the plaintiff. And that order was defective in so many ways, it's hard to count. But even after the order was entered, it wasn't served. It was served 8 days after it was entered. Service of a temporary restraining order is supposed to be immediate. Then, critically important, any temporary restraining order must have findings, mandatory findings. An order granting an injunction or restraining order must set forth the reasons for its issuance and must be specific in its terms. Each of the four elements has to be laid out, and the TRO must describe the injury and state why it is irreparable. None of that occurred here. And the order itself is not at all clear on its terms. If the court looks at the order, it's frankly unreadable. I made a reference to the order not being served until 8 days. I'm not suggesting it ever was properly served. In the record, there's an indication that it was mailed, not by the plaintiff, but apparently by the court. It was mailed to that same address on 8 days after it was entered. That's not proper service. And there's no indication at all that it was ever received by anybody at any time. But I want to go back to the deficiencies in the order. The order is supposed to be reasonable describe in reasonable detail the acts restrained. But if we look at the actual order essentially says, and we don't have a lot of time here, and I know the court has the order in front of it. It says that the property and estate shall cease and desist any and all trades. The property and estate, as the order, in the terms of the order, it's not Mr. Combs who's being restrained. It's the property and estate. Now, that's how it was written by Mr. Smith. It was written improperly, but it was entered that way. So the order is completely incomprehensible. Your Honor, we have a limited amount of time, and I need to talk about the default judgment because
You have
everything.
about 5 minutes. Obviously, I've read everything. So you have about 5 minutes, please.
Okay, quick. Everything about the default judgment was incorrect. First of all, the court obviously has no jurisdiction because of the lack of service. But second, a motion for default judgment, of course, has to be served. If you look at the proof of service, the proof of service says it was served on August 6th, 2024. The default wasn't even entered until August 23rd. So that can't be proper service. Second, the actual service of the default entry. The default entry must be served. The court is very clear on that. The court rules are clear on that. But in this case, if you look at the docket, you look at docket entry number 11, the default entry is not served. The line where it says it's been mailed is not signed. There is no evidence that the default entry was served, and that's a precondition to any default judgment. Now, the default judgment itself there's no indication that that was properly served, the motion for default judgment. And the default judgment is defective on its face because the motion from the plaintiff stated, if you read it carefully, says he seeks entry of an order in favor of the plaintiff in the amount of, and in numbers he wrote out, $100,340.10. In words, he wrote 100 million. Now, while that was an error by the plaintiff, that error was repeated by the court when the judgment was entered. If the court looks at the judgment as it's entered, the court will see that there are two separate numbers on that page. And one of them is $100 million when it's totaling, when it's identifying the components. And the court can just look quickly at the default judgment. You look at the components, and the components of the judgment shows $100 million, then $310, but the judgment is for $100 billion, $310.40. Your Honor, there are so many technical errors, but when we look to the transcript and we saw what occurred, there was never a proper affidavit by the plaintiff. The affidavit didn't say he swears to the damages. He says, I will swear to the damages. He never swore to the damages. There was no testimony from the court. And as this court well knows, since Wood v. DAIIE, a default may establish liability, but if a defendant comes forward, the defendant is allowed to defend and argue against damages. In this case, that opportunity was not provided. In fact, if the defendant demands a jury trial, the defendant is entitled to a jury trial in a situation such as this. Here, you had no evidence on the record of the damages. The court was supposed to undertake an inquiry into the damages, but instead the court just accepted the damages from the plaintiff, damages in a complaint that was not verified without an affidavit in support of the complaint. Now, Your Honor, there's so many different levels to this, but most importantly, the court has no jurisdiction because service did not occur. The TRO was improperly granted because there's no indication of proper service, but more importantly, equally importantly, there's no evidence of irreparable harm. There's no evidence of likelihood of prevailing on the merits because the statute of limitations barred the claims. There's no indication it's in the public interest. It can't possibly be in the public interest to enter this kind of an award. As far as the default judgment and the default entry was not proper because service hadn't occurred, but the default judgment was improper, partly because the default entry itself, even as of today, has never been served. No evidence of any attempt to serve it. And you can't have a default judgment without a default entry. And then, of course, there's no evidence to support the damages, whether it's $100 million or $100 billion. Either way, there's no evidence to support those damages. Your Honor, I want to be as respectful to the court as I can, and so I'm going to stop right now. And after Mr. Smith argues, I of course appreciate the opportunity to provide some rebuttal to the things he said and not return to the other issues.
Okay, so Mr. Cardello-Smith, you've got about 20 minutes. So your response? All right, I'm sending you a request to unmute. I had to mute you because there were noises going on. So it should unmute itself here in a minute. Do they need to do it? Usually it's just a button. Hold on. There you go. You're unmuted now. Perfect.
There you
All
go.
right.
Oh, okay, I got it. I haven't used one of
All
these
right,
in
you may
years.
proceed.
Okay. All right. The argument that, hold on, I don't know what this is. Hold on. The argument that Mr. Fink, can you hear me?
Yes.
You're
we
on,
can
say
all hear you.
something. Okay.
Yep, we can all hear you.
Okay, the argument that Mr. Fink, Mr. David Fink and Mr. Nate Fink made are rooted in lies, falsity, blunders, and it's absolutely false. if you look at the proof of service, there's a tracking number on that. That tracking number cannot be faked. We turn these documents in to the mailroom, our staff. That tracking number shows that I paid $10.40 out of my inmate account for the United States Postal Service to serve it at Mr. Combs' address. The reason we know this is his address is because I have the entire United States Department of Justice on my side on this, because in March, they raided Sean Combs' home, is what they did, in the Homey Hills, California area, which is 200 South Maple. That is his house. That's where he's at. You can have a different home in Florida. That's still your house. It's his. He lives there. The feds do not just raid a house that's not on a defendant and then arrest a defendant the day after, or the day after I get my judgment, arrest him and it not be his address. It doesn't work that way. Sean Combs lived at that address. That is his home, period. And that tracking number shows it was delivered there, paid for, and the green card was signed by him and sent back to me. I made copies of it and I sent it to this court. Regarding the amount of money and the relief, that summons is very clear. Notice to the defendant, in the name of the people of the state of Michigan, you are notified that you are being sued. Failure to answer could result in the relief being entered against you. You had 21 days by regular proof of service, personal service, 28 days by U.S. mail. He went past the 28 days, period. That man got that. That man signed for it. And now he's going to lie through his attorneys and say he never got it. His credibility is shot. He said he never lied. He said he never beat Cassie. Cassie sued him. And then the feds release a tape of him beating Cassie. And then he comes out and says, I'm sorry. So their client's credibility is completely thrown. He has no credibility whatsoever. I'm the prisoner, and I have way more credibility than he does. Regarding this affidavit from Kim Worthy in Wayne County, in March of 2020, she ran against a young lady named Burton Harris, who damn near got her job out there. But prior to it, Kim Worthy had to file paperwork with the elections board that said, all the documents I'm filing are true. And then it was and she did that by affidavit. And then it was also proven.
Stop everybody real quick. And Mr. Fink also, Kim Worthy's signature on any alleged paperwork was irrelevant to any of these proceedings.
All right.
So
Okay.
Whether it's her signature or not, that part of it had no bearing on anything in this case.
Okay, no problem. All right. The reliability on her and him saying I suborn perjury is attack on my credibility and the court's credibility. This court did everything right. This court processed it. This court heard it. He saw the hearing on August 7th. He could have popped up after that. He didn't pop up after that. He didn't pop up until September 9th when the judgment was entered against him. He knew all about this. He's on Law and Crime Network making comments about this. He's over there with Gene Deal making comments about this. Your client knew about this case before the $100 million judgment was entered. He could have shown up at any time. He lied, he stayed away, so he got served. And that tracking number is all the proof I need as far as my credibility to show it. The default entry was done properly by Ms. McCrane. I requested it, it was entered, and then I mailed it to him. The copy he's talking about that didn't have the signature, that was the copy that I got back. I signed it, then I mailed it to him. At first he said he never got served, and then he cleaned it up and said, oh, he did get served. That's a lie right there. Mr. Fink made that statement. So he's lying too to this court by saying he never got served the default. I served the motion for default judgment using money out of my inmate account to pay for the postage to send it to Mr. Combs. So I know he got it. And regarding the temporary restraining order and regarding the interest of the public safety or the public interest in that man signed an agreement with me and he has not denied the agreement. In Kim Worthy, all of these people signed an agreement entitling me to 49% of his company. That's $400 million I could have went after. I went after him for 100 million for what he did. So this temporary restraining order should stay in place because that is in the public interest. Regarding all of my filings, I fight because I fight. I don't like my rights being violated, nor anyone else's rights being violated. These people have presented Carly's writ as false. However, if you look at Mr. Proctor, the gentleman who came up, he's an investigator. He spoke with Mr. Vincent Smothers, a hitman out of Detroit, who attended a meeting that had Carly Carpenter there, Patricia Penman, who's the lead Wayne County investigator in charge of the Public Integrity Unit. That meeting in 2007 was to take me out on behalf of Wayne County, but he didn't do it. And his affidavit explains exactly just that. That's why Mr. Proctor was here, for that investigation. And he has that report. So it implicates Kim Worthy's office all day long. And her own office used Mr. Vincent Smothers' testimony to free another guy. So he's very credible. He's very credible. And I'm very credible. Carly Carpenter was a woman who issued a report on a rape charge in 1997 after she was already a victim of your client, Mr. Combs, one of 14 women. She didn't want to prosecute the case until she was harassed by Patricia Penman, who's at the Public Integrity Unit of the Wayne County Prosecutor's Office. In 2018, that's when she decided to press charges because she was paid to do that. Then she contacted me at the prison, asking me to help her get out of this because she lied. I told her exactly what to say, which is the truth. I said, if I did this to you, then let it stand. You know I didn't do this to you. So she allowed it to proceed. Also, at my preliminary examination on the case, my criminal case, I questioned Ms. Carpenter. She said only one person assaulted her that night. It was me. However, she also testified that she was kind of hesitant. She was a little shaky about it because the lead investigator and the prosecutor was there harassing her. I had a witness who actually testified that Carly Carpenter slept with two people at the same time, not just me. But she was paid $4,000 by Miss. I'm sorry. I'll get back on track.
Get back on track, because that's what
I'm pulling a feed. I'm sorry. I apologize. We have an agreement. Bottom line is, you served. The service was made. You issued a very righteous decision, a fair decision. The people here, Mr. Fager, who's providing all these documents and all this information that Mr. Fink spoke about on Monday when we had our hearing, he said, information is coming in every minute as we speak. That information was coming from Mr. Fager. Mr. Fager is a gentleman who I sued 3 times previous to this, even as far as September 6th, he said. All these lawsuits in the Western District, case number 1:22-00149, specifically shows I sued Mr. Fager, and 124-CB00308. That shows I sued him. And in that case, I charged him with filing forged documents, falsifying documents. This was back in May. This before we even had any hearings out here, Your Honor. So my history of challenging this guy for forging documents is clearly established. Regarding this whole thing about Monroe and Adrian, Fishbone's Rhythm Kitchen, where I worked at, is located in downtown Detroit on Monroe and Brush. So I had Monroe on my mind because I worked it a lot. I'm in here using a cheap little typewriter, and I admit, we have a spell check, and it didn't go off when I hit Lenawee, because if you type in Lenawee on a word processor, it should beep as a misspelling until you enter it as a word in your dictionary. I never did that. So I was typing the word Monroe in there. That's why I whited out Monroe, because it's not Monroe. And I had already mailed it out, turned it into the mailroom to send it. We took $175 out of my account and sent it to the Monroe court. That's why the case is filed in Monroe. But notice there was never any action. There was nothing done because I was going to have it transferred to this court until this court received the corrected copy that I did white out and did send to this court because I wanted everything preserved. This isn't court shopping. This is a man who was the victim of a crime and who had a public interest and who had a right not to be sexually assaulted and a right not to have my money taken from me. That's what this is about. That agreement specifically said that he is not to be caught up in any federal actions. When he got caught up in that March, that's what broke it. Regarding the statute of limitations, the statute of limitations is brand new because on April 4th and April 5th of this year, Kim Worthy's office tested one of 11,341 rape kits. She got money to test 11,341 rape kits, and she did it. The one rape kit is semen from Mr. Combs that she's kept for years. So when it was discovered on April 5th, that takes care
Mr.
of-
Cardello-Smith, Mr. Cardello-Smith, I apologize. Just as I had to advise, Mr. Fink that we are, we gotta stay on topic and
Yes,
we got
ma'am.
about 4 more minutes, so
Okay,
wrap it
I'll
up.
take it. All right, yes, ma'am. The statute of limitations is upheld because this man was identified as my raper, is what he was identified as. So that takes care of the 3-year statute of limitations. Your court has subject matter jurisdiction that they never argued. They stayed away from that. They're very skilled at this. 2.116 gives you subject matter jurisdiction over this case and the property. Personal matter was obtained as soon as the service was made. Everything that they're saying that you don't have and you didn't do is false and it's a complete lie. You have subject matter jurisdiction and personal matter jurisdiction, but they didn't argue subject matter in any way, shape, or form. Your judgment should stay entered because you did everything right. The TRO should stay entered to ensure that I get the damages for this. Everything should stay in place because you did everything right, period. You didn't do anything wrong. I did everything right. I made some typos. I made some errors. I'll admit it. I'm not perfect. I'm working under some crazy conditions. I get it. But I'm a plaintiff and I'm litigious because I'm a fighter. I'm a fighter is what I am. And I will always be a fighter for my rights and other prisoners' rights. But this matter here, you should not set anything aside because it was done properly. It was done perfectly. It couldn't have been better. They just don't want me getting this money because I'm a prisoner. That's what it is. The state of Michigan does not want me getting it. You get everything right, Your Honor, period.
All right, so Mr. Cardello-Smith, I'm gonna stop you there. I am going to mute you again because of feedback. Mr. Fink, you have about 10 minutes.
Your Honor, I'm going to try to address the issues mostly in the order that they were presented. And I want to start with something a surprising and clear admission that Mr. Smith just made. He advised the court that he paid $10.40. Your Honor, the Postal Service for $10.40 will send a return receipt request, but will not provide adult signature restricted delivery. And that you have to pay an additional $11.65. It was not paid in this case, just as he just admitted. And that's consistent with the 2 cards that the court has seen. The fact is, he did not restrict delivery to the addressee. And because he didn't, that card did not have to be signed by the addressee. Now, to be clear, it isn't because the court has seen the card. Mr. Combs' name is no place on the signature line. That's not his signature. It doesn't look like anybody's, but more importantly, the printed identification below it is not his. And then critically important, the court has seen that the card was doctored, whether it was doctored by Mr. Smith or by some confederate of his, it doesn't matter. It's a doctored card. The first card shows, consistent with the post office rules, that it was not restricted delivery. And I appreciate him admitting on the record that he only paid $10.40 because that doesn't buy you restricted delivery. That's what the problem was. Now, spent a lot of time today on service. But even if Mr. Combs was served, and he wasn't. But even if he had been served, this is a classic case where default should be set aside. He came forward on the day, or literally the day after he learned about the entry. And by the way, this nonsense that we're hearing now, that Mr. Combs made some public statements before September 9th about this case is patently false. He makes a reference to law and crime. While we're here, I Googled, and there's nothing in law and crime from Mr. Combs before September 9th. Mr. Combs didn't know about it. He didn't sign for it. Now, for some reason, we're being told now by this witness / plaintiff that Mr. Combs didn't deny the agreement. Of course, Mr. Combs denied the agreement. Mr. Combs denied the agreement. Ms. Worthy denied the agreement. Mr. Combs, in his affidavit, denied everything in the complaint very clearly, very explicitly. And when Mr. Smith says, well, it's just my word, I'm saying these things and you haven't heard from Mr. Smith, that's not true. We gave you an affidavit for Mr. Combs. We gave you an affidavit from Mr. Combs, and it's very, very clear. And this insane explanation that he sued saying it was at a hotel in Monroe, a Holiday Inn in Monroe, because he had been at Monroe and Brush in Detroit is beyond comprehension. He filed a lawsuit. That lawsuit hasn't been dismissed. He filed 2 lawsuits on the same exact day. And in one lawsuit, he said this happened in Monroe. And in the other lawsuit, he left it blank and claims it happened in Adrian. And he just didn't do his research well enough, because Monroe did have a Holiday Inn in 1997. Adrian did not have a Holiday Inn in 1997. He's making this stuff up as he goes along. Now, Your Honor, he raises what sounds like a more sophisticated argument when he says, well, what about subject matter jurisdiction, Your Honor? Until you have personal jurisdiction, subject matter jurisdiction is completely irrelevant. There's no personal jurisdiction over my client. No personal jurisdiction, because he has not been served. And if there was any question about whether he had been served, and there wasn't from our perspective, that question disappeared when he just told us that he only paid $10.40, because for $10.40, you can't buy addressee only delivery, which he had to have. Now, he hasn't responded to the basic issues that we've raised. It's an injunction for 90 days. The rules are clear. It can only be 14 days. The reasons are not provided in the order. The court rules are very clear. Reasons have to be provided in the order. The order has to be reasonably clear in describing the matter enjoined, and it isn't. The injunction was supposed to be served, and there's no evidence that the injunction was ever served. But that's after it was entered. Regarding the default judgment, he has no explanation for why it is he did not sign, nobody signed, that the default entry had been mailed or served. And if you don't serve a default entry, you can't get a default judgment. It's that simple. He didn't serve the default entry. He doesn't even claim to have served the default entry. He didn't serve the motion for default judgment properly, as I told the court. His so-called proof of service says it was served on August 6th, but there wasn't even a default as of August 6th. So he didn't serve that motion. And notwithstanding all of these things, notwithstanding the fact that we weren't served, that the client wasn't served with the complaint, we weren't served with the default judgment, we weren't served with the default entry, we weren't served with the temporary restraining order, despite all of that, we came to this court immediately when we found out about this. And we're very grateful to the court for hearing it, for giving us this time on its busy calendar. But we came immediately and we challenged every one of these things, and we haven't had a single substantive response. What we've heard is a prisoner who's serving time for multiple felonies and who claims he didn't do that. He didn't commit these acts, and everybody else is lying and he's innocent. Your Honor, I venture to say that almost every prisoner where he is currently residing will give you the same answer and tell you they're innocent too. And maybe some of them are, but the fact is he doesn't, by being in jail, in prison, he doesn't get rights that the rest of us don't have. He has to follow the court rules. He has to follow every step, and he didn't follow any of these steps. He doesn't explain why the complaint's not verified and there's no affidavit in support of it. That by itself throws all of this out. You can't have a temporary restraining order without that having been sworn to. He doesn't explain why he didn't serve these things. So, Your Honor, I appreciate so much time from the court. I really do. I will simply point out that we hope the court has seen our supplemental submissions, but in the end, this is an incredibly simple case. No service, no jurisdiction. And we really would appreciate it if the court could act quickly on this and dissolve the temporary restraining order and set aside the default judgment and the entry of default. Give us an appropriate amount of time to respond. We will respond, of course, right away.
All right, very good. Thank you. So a central complaint of both defendants' motions, currently before the court is the claim that defendant was never properly served with the summons and complaint in this matter and was therefore unaware of the proceedings. MCR 2.105A2 specifies that service of the summons complaint may be served upon a non-resident individual by sending a copy of those documents by registered or certified mail, return receipt requested, delivery restricted to the addressee. Service is made under this rule when the defendant acknowledges receipt of the summons and complaint, and the return receipt must be attached to the proof of service. There is no requirement that the summons and complaint be mailed only to defendant's primary residence. A party may not simply announce a position and leave it to this court to make the party's arguments and search for authority to support the party's position. Wilson v. Taylor, 457, 232, 243, 577 Northwest 2nd, 100, 1998. The court received a return receipt indicating that the copy of the summons complaint was mailed, certified mail, delivery restricted to the addressee to Sean Combs, 200 South Mapleton Drive, Holmby Hills, Los Angeles, California, 90077. Defendant does not deny that this is a residence Mr. Combs owns. The court acknowledges that the date of service on the return receipt was difficult to read and could either have read 7621 or 7624. However, given that the case number for the incident action filed in 2024 was included on that return receipt, the court at that time found the date to either be 7624 to be a typographical error. The court had no reason to believe the date was fraudulent. The court also acknowledges that the signature on the return receipt is utterly illegible, but indicates that it was signed by the addressee. Defendant's review of the proof of service indicates something the court previously did not note, the lack of delivery restriction to the addressee. Accordingly, proper service was not made under MCR 2.105A2. However, the court finds that the defendant did provide notice by mailing a copy of the motion for temporary restraining order to the same address. Accordingly, the temporary restraining order was not issued without notice, as defendant alleges, and those procedural requirements do not apply under these circumstances. As a result, the defendant's failure to contest the TRO, the temporary restraining order, was issued. However, the court is persuaded by the defendant's arguments that at the very core of this matter is the statute of limitation issue, which makes it unlikely that plaintiff will succeed on the merits. As a result, as detailed in defendant's briefing, plaintiff cannot satisfy the four-pronged test to establish entitlement to an injunction, and the temporary restraining order will be appropriately set aside. Defendant's motion to set aside the temporary restraining order is therefore granted. Turning next to the motion to set aside the default and the default judgment, as the court previously addressed, it finds that defendant was not properly served with the summons and complaint. Moreover, the court notes the policy of this state generally favors the meritorious determination of issues and therefore encourages the setting aside of defaults. Huggins v. Bowman, 228, Mich. App. 84, 86, 578 Northwest Second, 326, 1998. The court finds that the defendant has established procedural defects sufficient to establish good cause under MCR 2.603 D1. The court further finds, as it previously indicated, that defendant is likely to have a meritorious defense in at least the statute of limitation arguments. Having fully satisfied the requirements of MCR 2.603 D1, the defendant's motion to set aside the default and default judgment is granted. The default judgment previously entered is hereby vacated. The court at this time will send out a pretrial notice to the parties based upon the emergency pleadings filed. It appears that defendant would like a hearing date for a motion for summary disposition. And there will be at least 30 to 45 days out to allow defendant to file the motion and give plaintiff 28 days to respond. So would you like a date of October 30th at 10 a.m. for 2 hours? I'm sorry, October 31st at 10 a.m.
I apologize, Your Honor. What I don't know is the court was setting for October 31st. I didn't catch what the court was setting for October 31st.
Oh, my assumption is at some point you'll be filing a motion for summary disposition.
Yes.
So I was
Yes.
going to give you that date now.
Oh, that is, I appreciate that. And that's what I thought the court was saying. I didn't want to interrupt, but I have a previously scheduled full day mediation on that date on October
Ms.
30th.
Adams, could I get another date in November for 2 hours, please? And that'll give you plenty of time to serve Mr. Cardello-Smith, and that'll give plenty of time for Mr. Cardello-Smith to file a response.
Judge, we do have the afternoon of November 8th.
November 8th at 1:30 p.m.
Your Honor?
Is that day good for you, Mr.?
No, I've got a probable cause conference remand hearing for 5 prisoners that didn't get one in their criminal case on that date. It's gonna take
Okay.
up the whole 2 weeks of that. Can you put it towards the end of November?
Ms. Adams?
I'm looking.
Your Honor, if I may, perhaps an earlier date than October 31st would make sense. It's a little odd when a prisoner has his own criminal docket that he's handling for other prisoners, but I respect his schedule. But we do want to get this done sooner. I didn't count out all the days as the court was graciously going through.
I'm fine with setting this out to November. That gives him ample time to respond. Because there are some mail delays with MDOC.
Oh, yeah. And Your Honor, can I put my notice of appeal on the record at this time? Or excuse me, my notice to file a motion for reconsideration of this regarding the statute of limitations and ask for subpoena power to help meet the statute of limitations based on documents that are currently in the possession of Adrian Police Department, Lenawee County Sheriff's Department, and the Wayne County Prosecutor's Office?
So you have the right to file a motion for reconsideration and request that relief, but I'm not going to grant those reliefs today. No.
Okay, no problem.
Okay. Okay, hold on, let me see. Maybe. All right, I have a civil, criminal, and family law docket, so I'm on the bench about 8 hours every day. So my docket, I don't have like 1 or 2 hearings a day, so finding a day, because obviously my family law and my criminal docket will take precedence over any civil. Let me see here. It's not 45 days out. So at least do 45. I can do Monday, November 4 at 2:30 to 4:30.
Perfect.
Mr. Fink, is that good for you?
That will work, Your Honor.
And that gives you the time. All right, so, obviously, I'm just giving you the date for that, and I'll set a pretrial as well on the same day. So, Mr. Fink, so Mr. Cardello-Smith and Mr. Fink.
Yes, Your Honor.
Mr. Fink will serve you with his motion for summary disposition timely, giving you ample time to respond. And then we'll come back on November 4th at 2:30 for 2 hours. Hold on one.
Your Honor.
And Mr. Fink, you will do the order from today and then put that notice in there as well.
Okay, the order will just say for the reasons stated on the record, we'll submit
Yes.
that. Now, do we need to submit it to Mr. Smith for his review or just submit it to the court?
So if you submit it the day of the hearing, I will sign it.
Okay, we'll submit it today.
And then also if you can attach part of it, that the court scheduled a summary disposition motion for that day. And that way, Mr. Cardello-Smith will have any paperwork he needs. And then when you serve the motion for summary disposition, you'll do another notice, of course.
Your Honor, can we serve Mr. Smith by email? We do that with all the other, with attorneys all the time.
Well, Mr. Cardello-Smith, do you have access to JPay or any way to receive that via email?
No, I need paper service through the mail, ma'am. We have JPay, but these people have too much access to it. It helped them win.
Okay,
The
so
Okay, Your Honor,
we'll do mail.
I'm not trying to force the issue, and we've done fine getting it served by the prison. Can we provide the order to the court by email?
Yes, you can email that to my judicial attorney. I believe you all have her email address. And as long as that's submitted before 4:30 today and it accurately reflects what I ordered, I will sign it.
But believe it or not, we have not been communicating with her with email. I don't have her email address.
Okay, I'm gonna send that to you in a chat. Mr. Cardello-Smith, you have communicated with her. So, hold on one second.
Yeah.
All right, so Mr. Fink, I am going to send you, it's trying to look. All right, Mr. Fink, I'm sending that to you now via chat. Can you write it down, please, or copy and paste it?
Okay, I have it here. Thank you, Your Honor. I've saved it. Okay.
Okay, excellent. All
Um,
right, so
Your Honor,
I will.
Your Honor, there was one, I apologize. I wanted to just say one more thing, if I may, on the record, with an abundance of caution. I have not yet obviously had an opportunity to consult with our client regarding the court's ruling and so in our next steps. So while I do anticipate that the court is correct, and our next step will be filing a motion for summary disposition, having not consulted with the client yet, I don't want to make a representation to the court. We may or may not file that. We appreciate having the briefing schedule. I think it's the most likely next step, but I'm not certain that's our next.
Either way, put in the order from today that a pretrial will be held that day as well. So at the very least, we'll hold a pretrial that day.
Your Honor,
Yes, sir.
I too will be filing a motion for summary judgment in my favor, according to the pretrial rules. Okay?
Yes, yes.
This isn't
of
over,
course.
Mr. Fink. Let Mr. Combs know that this is not over.
Very good. Everybody will file whatever they deem is appropriate. That concludes this hearing. Thank
Thank you,
you.
Your Honor. Thank you.
Thank you all.
She kicked me off so fast. She's like, thank you, click. Okay. Okay. Thank you guys so much for watching. This was the Cardello-Smith versus Sean Combs case. As you guys know, they were headlines of which this man got $100 million default judgment against Combs. And prior to that, he actually got a restraining order against Sean Combs, where he couldn't sell any of his assets. And that video is actually, going around. I saw a clip of it as well. So he got the restraining order first. So David Fink, who is an attorney, all this is happening in my neck of the woods in Michigan. he is a, a great attorney here. I'm not going to say what I was going to say. It was going to be a little arrogant, but he's a good attorney, and he was representing Combs in a limited capacity as for these hearings. So he was trying to get the restraining order set aside and the judgment set aside as well, which he was. So which he prevailed on. Now, I'm not going to lie. When I first started hearing her talking, I'm like, is she going to let this keep going on? Because she was sounding a little favorable to him. But I think what she was trying to make clear, I think she tried to find a way where it looks like she didn't jack up. Like it wasn't her. It was other circumstances or whatever. I think that's how she made it, to let her know you can serve someone and it doesn't have to be your primary home. And he did it in the right way. But now when I look back at it, she wanted to make it clear that I know some of y'all looking at me like I done messed up, but I ain't messed up, okay? But then ultimately she gave what the defendant wanted. He was very, very thorough. But as you see from Mr. Smith, he is a litigious person. He has sued everybody. People were asking me who Kim Worthy is. Kim Worthy is our prosecutor. So it's like the Madam DA Fonnie Willis of Michigan. She is our head. We call them prosecutors. We don't call them DAs. So she is our head prosecutor. The conviction integrity unit that was brought up by him is our unit that is it's like an arm of our prosecutor's office, and inmates can send when they think they have new evidence in order to have the conviction integrity unit relook at their cases. So they're kind of like a innocence project almost, but it's funded by the state, and it's a arm of our prosecutor's office. So he was mentioning all of this stuff in the CIU. Now he did mention Vincent Smothers. So Vincent Smothers is a guy who is he was a serial killer, like he was a hitman. And the case, why he's trying to say Vincent Smothers has credibility on whatever he's saying, people was trying to take him out. That's what he's alleging. Like, Diddy sent people to take him out and all of that. Smothers, actually, the wrongful conviction that he was referring to was there was a young guy who was 14 years old. He actually came in and was confessing he had some intellectual delays. He came into the police department in Detroit and confessed to a crime he did not commit. A lot of it was fed to him. It seemed like they showed him what the layout was of the murder and all of that. He was only like 14. Vincent Smothers was already locked up for a whole nother murder on that day. He was trying to tell the police, yo, this young boy didn't do it. I did this crime. It was me. They dismissed Smothers and they convicted this young man. His name was Devontae Sanford. They convicted him of murder and he went to prison. After 7 years, basically Smothers was talking to different people and reporters like I'm in prison for the rest of my life. I'm telling you all the bodies I got. So he had a slew of bodies, and it was also the one that this young man was in prison for. So to say he's credible is a stretch, but he was honest about it was me that actually killed him. So Devontae Sanford, I'm sorry, he got out of prison after doing 7 years for a crime he did not commit. And he was able to get, I think, $1 million per year for each year that he was in prison. So that's the whole Devontae Sanford. I don't know why he brought up Smothers and Devontae Sanford, but I figured since he brought it up, I'll tell you guys what he was talking about. Sounds like this guy is actually the attorney for the complex. I don't know, because he's giving his scheduling dates on when he's helping people. Now, I did hear that some people get paralegal certifications of some sort, or they become the paralegal for the jail. I did hear that when I was in the prison about 2 months ago. I was like, huh? Somebody told me, like, yeah, I'm the paralegal, for the jail. I was like, oh, okay. So apparently they do have people that I'm sure he's probably getting paid to help people with their cases. But as Mr. Fink pointed out, he is in there for the same allegations that he is accusing Diddy of. There were a lot of discrepancies that were brought up side by side with the evidence at this hearing we heard on Monday, which was the first part. and go to my Instagram or go to my TikTok. Follow me, pam.esq, so that you can see the little clips if you don't want to watch the whole hearing from Monday. But I'll attach the whole hearing at the end of this. Ultimately, everything was set aside. The judge is aware that Sean Combs' team is probably going to file a motion to dismiss the case, which I presume is going to be granted because there are statutes of limitation issues. That is one of the prongs that the judge had to weigh when it came to whether there is a possible prevailing on the merits. But that's something that you have to go through before issuing any type of, setting aside a judgment. So he does have the possibility of winning just based off the fact that there is a statute of limitation issue. The judge wanted to stay away from his litigiousness. I understand that because I think there's a lot of judges that just see him and they just dismiss it. But maybe she wasn't privy to how this person was. And once Fink was showing all this evidence and he was making statements like all you had to do was to do the most minimum investigation and you would have known. And it's kind of like, in my opinion, I think that it looked like the judge didn't know what was going on and what was happening. So I think she crafted her opinion in a way of which it made it look like, hey, I didn't get it wrong, but I get what you're saying, defense attorney, and you're right. We should set this aside and, whatnot. Because honestly, if she didn't do it, I'm sure he would have appealed and it would have probably came back down on appeal. But nonetheless, I guess it's a semi-win for Diddy. The case is going to go on and that judgment is aside, and that restraining order has also been set aside. Let me see the super chats. Thank you so much, Pensy Lola, for the super chat. I appreciate that. WIRF TV, thank you so much for the super chat. I appreciate that. And the official Thais report said, oh yeah, he spends most of his days in the prison law library. Thais, absolutely. We just learned that. The little gaming channel said, let the brother get his jailhouse legal on. Let him cook. He was doing his thing, right? He was against a seasoned attorney. I think he said his P number is like a 2. So he's been practicing. Fink has been practicing for a little minute. He's probably like 40 something years in the game. Because he's like a 2, I'm like a 7. When we start our P numbers, that's how we kind of can tell how long you've been practicing. They're like on like 8, like late 8s or something now. So yeah, he's been doing this for a minute. Granny the Great said, my offering for today's lesson. Thank you so much. I appreciate that. I hope you guys appreciated the stream. Rewatch it if you're just coming in and you missed it. We had the entire hearing of the Cardello-Smith v. Sean Combs case. I'm very interested to know if he doesn't know. He brought up Cassie. Smith brought up Cassie. Sean Combs is a liar because he said he didn't beat Cassie, but then the video came out. So we know he's a liar. I'm more credible than he is. I mean, that was a big stretch. But, I got where he was going. I picked up what he was trying to put down. But I'm wondering if he knew that Diddy was actually arrested and is in jail, because it seemed like he would have mentioned that. Right? Like, why wouldn't he mention that? If you're going to mention Cassie, why wouldn't you mention the entire arrest? That's what I would think. Yeah, I know it's supposed to be a hearing at 3:30 where Diddy is appealing his no bond status. And so I'll try to come back then if you guys are interested. But again, nothing is being filmed in the federal court. So the only thing we would have is if the attorney comes out after the fact and does a press conference. And there are people like the Associated Press and a couple of other people that are in there that are live tweeting a lot of the things that are happening while they are in the court. So if you want to stay updated on that. And I think that's it. You guys have any questions? I'm surprised though, the handcuff thing was kind of throwing me off because so typically, and I'm not saying this is the same for court proceedings because I don't think I've ever had a video court proceeding with an inmate. But when I've gone to see them, when we do our attorney-client face-to-face, they're not in handcuffs unless they're like in solitary confinement or something. Like unless they're in solitary confinement, I did have one time where an inmate had came and they had him in handcuffs because he was like in the hole, basically. But for the most part, they're not. Yeah. Does Diddy kids get to be in the courtroom? Yeah, it's open. Courtrooms are open to the public. They'll probably let the family in the courtroom before they let anybody else in the courtroom. And then once it gets full, of course, it's probably going to be first come, first serve. They probably have to do a section for press and then a section for like his family and then maybe some for the public. But yeah. What happens next? Because the inmate said, tell Mr. Combs this ain't over. He's like, it ain't over. Yeah, basically he's trying to say he's going to counter with the motion to dismiss. He's standing on his claims that Combs actually assaulted him. And what I thought was interesting, and he said he's worth 400 million. I only came for 100. Like, he's lucky I didn't come for more than that. Judge, you did everything perfectly fine. Everything you did was how it should have been done, Judge. You did great. But as you guys see, all that arguing and back and forth, 9 times out of 10, the judge already has what they're going to do written out before you get there. You just have the entitlement to oral arguments if you request it. There's been sometimes I've had judges that was like, I was prepared to rule, but because of the way that you brought maybe a case to my attention or new developments to my attention or whatever that I didn't consider, I'm going to hold off and I'm going to take it into consideration and then, do a written opinion later. But most times judges know what they're going to do before you get on there. You just arguing. And then at the end of the day, they have it right in front. They're like, according to MCR 2.116, then they just start reading it. They sit there and watch like. Then most of the time, though, when I do oral arguments, they cut you off, just like the Court of Appeals, and they'll ask questions that they feel like is the weakness of your case so that you can elaborate more on the weaknesses and not get so caught up in the parts, especially that the judge agrees with you on. So they want you to elaborate on those parts. But yeah, most of the time you going hard in the paint like you feel like you just left a boxing match. Because you see how Fink was, where he was like, and Judge, I just have to add this one more thing. It's like mental gymnastics. So sometimes you do feel like you were literally fighting, like you were in the ring. Like I had a hearing like 3 weeks ago, and I was like, I like need a nap. Like I really need a nap, So sometimes that is how it is. So I was feeling his exhaustion, and then I can't imagine going against an inmate that like spends 24 hours in the law library, and then they're doing their own cases trying to sue everybody. Then they're doing other people's cases trying to sue everybody. They dang near are going to know the laws and the rules better than you can. Now, of course, it always ends up coming out like what Fink pointed out. You can't get the subject matter jurisdiction till you get to personal jurisdiction. There are going to be certain nuances that you just probably don't know. But I'm sure he probably found cases that we haven't seen from the 1820s, because he spent all that, his whole time doing it. And he's made this almost a niche. You see how he addresses the court. I've seen him address the court better than other people on these streets, on these YouTube streets. The way he addressed the court, the way he presented his argument, he got all to the left a few times where he started talking about rape kits. You guys may have heard about that. And I think it's interesting that he was able to come up with that. I think that was kind of clever. It was very interesting. I don't think it's true, but I think it was clever because there was a situation here where there was a warehouse and it became a part of a Law and Order SVU, because that's my favorite show. and it was a bunch of rape kits that were in a warehouse and they were untested. So there was a time where Kim Worthy, who was the prosecutor, went before our city council to get funding in order to go through these rape kits. And I know that she has went through some of the rape kits. I don't know what status it is now, but to be like, yeah, my stuff was a part of the rape kit. But it's like, dude, well, you should have some hospital records then. If you went through all that where you have a rape kit, then you should have medical records that show that they swabbed you for it. You know, so he would have to show, you know, be showing that. And what hospital did you go to where a rape kit was even tested? Because that's what he basically alleged, is that, oh, it's stuck in that warehouse where all those other kits weren't tested. I'm like, but there was also where you had some people that were, their cases were overturned and they were granted retrials because our Michigan State unit that does testing of like ballistic testings, our forensic unit, it turned out that they were doing some shady stuff. And so there was money that was allocated. They shut down the whole unit and then had to retest a whole lot of evidence because there were people who the guns weren't matching. They lied and said the gun, they found matching bullets in somebody's house and it was this gun, but it was switched out. It was crazy stuff going on. So they had to like retest. So a few of my clients, they got letters that they were going to retest those. So there are incidents where they find out there was some type of corruption or shady stuff going on and they've had to retest stuff. And some inmates have been found to be innocent because of it, that it was basically fabricated evidence that was presented by some of these old shady people. But so the fact that he brought that up, he just hears, being an inmate, he hears all of these stories. So he knows why certain people have been exonerated. He knows why certain people have been granted new trials. He knows all of that. And how I know that he knows is because when I have people that ask me to consider their cases, a lot of times they start comparing their cases to other people to try to convince me that they're innocent and that I should take their case. So I know that they do that. They don't have nothing but time but to swap stories. And oh, that officer was on your case and you were found to be, they said that he was shady. Well, he was on my case. So I'm going to compare and say he did the same shady stuff on my case. You know, that's what they do. So the fact that he knows the issues within Wayne County, he's utilizing it in this case from the rape kit standpoint, saying, yeah, that happened to me. That happened to me too. I gave the rape kit and they just ain't tested, which I think was kind of clever. I think it was a lie, but I think it was clever. Deb said, I'll let Fink know that I'll process Sir Smith at the jail. I think all his kids are attorneys now, because his name has been on a few cases that I've had. And I know I've went against him before. It probably was like 2016 or something. I think it's been some years since I've had a case against him. But yeah, listen, he Fink has, it sounds like the process server who served Smith those documents. Smith has now sued the process server, saying that he forged some signatures or something. Like he sued him in Macomb County. He pulled it up that he sued him. I was like, I'm gonna have to look that case up and get a copy of it. So he's trying to say he lied, that his process server lied about serving stuff. And I guess if he's doing this all the time, this isn't the first time that he's been interacted with this process server. Because he said this, according to Smith, he filed a lawsuit against this process server before he even served him in this case. So it must have been on another case. So it's a lot going on. But thank you guys for piling in here and watching. It's always better when we are social media jurors together. Make sure you hit that like button. I hope you guys, you said, question, why was Diddy not charged with the GUNs? So That's a very interesting question. So they did it. It's kind of like how they did it in a conspiracy. And then a lot of that stuff are like acts within the conspiracy and the enterprise. But don't think that just because they didn't charge him with something, they may not in the future. But the main thing is, I mean, you got X trafficking, which is a big case, and it has a statutory maximum of life in prison. So maybe they just wasn't trying to, throw everything against the wall. But I believe that there'll probably be a superseding indictment. I'll be surprised if they don't. And what is also interesting about the Diddy case is, and his attorney, the biggest argument is, I think they're trying to say a lot of these people consented. Like his attorney, Diddy's attorney for the criminal case, was saying that he's flown all over and talked to some of these people that were in these videotapes. So I'm assuming the attorney has seen some of these, or some of these people that were allegedly involved in these freak-offs, and they have not said that it was unconsensual or that anybody was drugged or anything against their will. So everything about this case is just interesting, and we're just sitting back. I don't want to speculate on what the U.S. attorney, he seemed like he know what he's doing. But could they have tried to find, especially with those defaced ones, perhaps? But then it was in a big house. There's other people that live in the house. Do you know that it was his GUNs? He has security. Was he really the owners? Remember, one of the guns actually had it was registered to one of his security. Were they really his guns, or were they just the security has the guns and they use it to protect him? Should he be held responsible for the guns that they found, even though it was security's gun? It may be a lot too. I just don't have enough information to answer that question. So Che said, yeah, I don't understand how you can fly ex workers out and get charged with ex trafficking. I think that's their argument. I mean, and they didn't say anything about, a lot of the stuff was about Cassie, and the argument with Cassie, I don't know if you guys heard this, but the attorney, from my understanding in court, alleged that video incident that we all heard in the hotel, that we all saw in the hotel rather, allegedly they were like in the midst of one of these situations where it was a threesome or something, and Cassie got pissed off. She took his clothes. She hit him with something. This is according to the lawyer. She bopped him upside the head with an object or something. She took his clothes and then left out, and that's why he was out in a towel. And that's, so he's trying to paint a picture of toxicity between just in the relationship, like they both abused each other. So, like, I want to say one of his security, Roger Bond, when he came out, that was in the pleading, he's made an accusation that I guess he's seen, if I remember correctly, I thought he said he's seen them hit each other as well. So I think that's kind of what they're going for. Like, this was just a toxic relationship when it comes to Cassie, because she's the main one. Her lawsuit, a lot of the lawsuit is what you see in that indictment. So I think that's what they're going for. So they feel like they can fight this, that this was a consensual thing. I think Boosie made a comment. I'm not listen, I have no dog in this fight. I'm just answering the questions y'all are giving me. Let me see. Shade Room. Boosie had just posted about it, because a lot of people were like, why aren't the celebrities saying anything? Because it is true. You don't see a lot of celebrities, but we've seen Diddy with a lot of these celebrities, and they're probably trying to separate themselves. Boosie says he disagrees with Diddy's charges. He said, I feel Diddy is in jail for basically doing what every other famous entertainer has done. Flew itches out for threesomes. He's just freakier. We actually go call women prostitutes who fly in willingly to be with their partners for X. If that's the case, if you've been flued out and had X, you should be labeled a prostitute. if that's the case, that's 80% of the women reading this. In trafficking, hell no. You're a celebrity. You gotta fly Ussy in. How else you gotta get the Ussy? You're never in one place. When I saw that video, I was pissed off at the ninja, like he really got a problem. I guess talking about the Cassie Hotel video. But facing life in prison for doing basically what so many other entertainers has done, I disagree. That's what he said. That's what he said. How does Cardello-Smith pay for these lawsuits? So that came up as well. Well, first of all, people in prison probably paying them to help with their lawsuits. But I know that they also have waivers for prisoners. And I think he is almost on the no-fly zone not to give him these waivers. That came up as well. But for prisoners, they can actually get their fees waived. But I think in this case, he's probably beyond that because he's on the no-fly zone. Like, this dude is litigious and he files frivolous lawsuits. So I assume if he's doing all this work for people in prison, they're probably paying him. So yeah. Dev just answered that question. Somebody asked, was it illegal to own an AR-15? And no, it is not if you purchase them legally. You can go purchase them at a licensed firearm dealer. Chris J said, Boosie needs to serve time for having his underage son sleep with prostitutes. Well, I mean, that some people feel that way. And I think that's basically what his argument is. It's like, well, when is there going to be a line drawn? Is this going to be a slippery slope? People get mad at you and they say all of a sudden, I don't like the way it was. He abused me. How many abused people that were in domestic violence relationships can come forward and say, we need to put them in prison? Because I had ex with them, even as a, we were married and I was abused or something, and they took it from me. Like, how, So I think that's what his attorney is trying to argue, albeit at sometimes inarticulately, but it's like the DA is implying coercion by showing the guns and the date rape drugs. Yeah. It's all a part of what they're alleging. So their point of like showing the guns was also that he is a threat to society. And he has people, which was very important for them to prove, to say that the bond should be denied. Now, again, this afternoon, there is an appeal because the person that determined whether there should be a bond was the magistrate. And so now, today, they appealed the decision and it's going to go before the judge that is actually going to be the judge presiding over Diddy's case. Thank you so much for the super chat. I appreciate that. Yeah, that thousand bottles on lube and baby oil was pretty rough. I'm like, what? That's not for flying women out. He running a darn illegal business. Well, listen. He is presumed innocent until proven guilty beyond a reasonable doubt in the court of law. And so we are all going to sit back and see what is what. So that's that. He's not in trouble for the guns yet, though. I think they were asking why he wasn't charged with them. Yes, removing serial numbers is actually illegal. I agree with that. But you also have to prove the possession on whose guns they were. What if they was his security's guns? What if they was his family members' guns? That's all I'm saying. So I don't know the justification for not charging with the guns. I'm just saying that may be something that they're pondering over, and maybe it'll come up later, or maybe they say it's not worth it because perhaps they can't prove the ownership of it or the possession of it. High Vibe said, thank you for providing real information, Pammy Pam. Thank you so much for being a member for 9 months. I appreciate the committed support. That's it. You know what? Yeah, that was crazy. That little clip that was out by Larry Reed. I was like, oh my goodness. Related to the baby oil. Anyway, all minds clear. If you guys can hit that like button and subscribe if you're new here, I would appreciate it, and welcome. And I thank you for all of my continual supporters. But I gotta go. I gotta get to work, and I'll talk to you guys later. We may be back again depending on what information we learn at this appeal proceeding on the bond this afternoon. Let everybody know about this hearing. Like, share, and subscribe. Talk to you guys later.